Good evening, Asia. Good afternoon, Middle East, Africa, and Europe, and good morning, North America. Welcome to the Knowledge Series 2020, the New York City edition. As some of you may know, we've been having a set of global conversations covering transformation in the legal industry. We actually started with a physical event in Mumbai, and then due to the pandemic, we pivoted to a webinar for Riyadh, and we did the same thing for Lagos. We were hoping that things would have subsided and we'd all be together in New York this time of year, but unfortunately that's not the case. But thankfully to technology, our community stays intact and we're together again for another conversation. Before we begin though, I'd like to just take a moment and dedicate this particular webinar to Justice Ruth Bader Ginsburg. And in doing so, I'd actually like to read two quotes of hers that I think embody the spirit of this particular conversation. The first one about women on the court. She said, "When I'm sometimes asked, when will there be enough women on the Supreme Court? My answer is when there are 9, people are shocked. But there've been 9 men, and nobody's ever raised a question about that." And the second on dissent and justice. Dissents speak to a future age. It's not simply to say my colleagues are wrong and I would do it this way, but the greatest dissents do become court opinions, and gradually over time their views become the dominant view. So that's the dissenter's hope, that they are writing not for today but for tomorrow. So in the spirit of those quotes, in regards to the first one, I am going to remove myself from the bench for this event, turn it over to my brilliant colleagues, Rachel Pether and Linda Fitzallen, who will be your co-moderators. And in terms of the second one, though not quite dissent, in the spirit of Justice Ginsburg, we invite you to participate, to be active, to use the features in this platform, and to challenge our panelists. And let's all have a spirited conversation and talk about these changes that are taking place in our industry and what the future holds. So thank you all, and over to you, Rachel.
Thanks so much, Dilip, and those were great quotes that you opened with as well. So my role is to give you all the boring housekeeping rules of today. As Dilip mentioned, this really is a discussion, so we do want to hear from you. Big Marker might be a platform that you're not so familiar with, so please just enter any questions that you have in the Q&A section versus the chat section, and we'll endeavor to get to as many of them as possible. One piece of functionality in the system is you can also upvote questions from other audience members. So please do upvote a question if you think it's particularly interesting for our panelists. One thing that we're actually trying for the first time today is co-moderation. So myself and Linda Fitzallen will be jointly moderating this session. Linda is the CEO of the ADGM Arbitration Centre, and she's also one of the partners for the Knowledge Series, which the partners for this are Phoenix Advisors, and we heard from Dilip just now, and also ADGM Arbitration Centre. So we thank them for their support. Linda, I'd like to hand over to you to introduce our fabulous panelists today.
Rachel, thank you very much, and welcome to you all. For some of you, you're returning Knowledge Series people, so welcome back. And for our new guests, it's terrific to have you. So it is my pleasure to introduce our speakers, and they have an extraordinary array of backgrounds and expertise. So if I may start with Tess. Tess Blair is a partner with Morgan Lewis. She's a litigator and legal entrepreneur who has practiced at the intersection of law, technology, and design for more than 2 decades. She's the founder of Morgan Lewis's eData practice, which is a data-driven practice that combines great lawyering with technology and design to enhance the delivery of legal services. In particular, she tests for clients, she counsels a host of Fortune 500 companies, conducting risk assessments and guiding her clients as they develop internal information, governance policies and controls to address privacy, security, retention and disposition of information and data. She is an extraordinary member of a team of counsel providing discovery expertise. And she takes and defends a record custodian and discovery related dispositions. She handles all discovery related motion practice and drives all managed review, analysis and production. So as the leader of eData, she works with a team for clients' benefit. So an extraordinary skill from Tess. Our next speaker is Houman Shadab. Houman is the Director, Professor of Law and Director of the Innovation Center for Law and Technology at New York Law School, and is a Fellow at Stanford Codex. He advises companies and financial institutions on issues relating to law, technology, and operations, and he co-founded the smart legal contract startup Clause. He has testified before the federal government several times, including before the Commodity Futures Trading Commission on Bitcoin derivatives and before Congress on hedge funds. He is often invited to speak at high-level academic, governmental and practitioner events, including events organized by the International Monetary Fund, The Economist, and the New York State Bar Association. And our final panelist is Eric Blinderman. Eric is the CEO, Chief Executive Officer of Therium. He is a seasoned international and commercial litigator who, while at Proskauer Rose LLP, has represented governmental and private entities in the US, Middle East, China, Europe, and Canada in complex litigation and international commercial arbitrations. Eric has also worked for the US Department of Defense and the US Department of Justice, including serving in Iraq as Chief Legal Counsel and Associate Deputy to the Regime Crimes Liaison's Office, where he served as the principal US attorney responsible for advising on all matters of law and procedure in the trial of Saddam Hussein and 7 other co-defendants. So we have the privilege of having our 3 panelists here today with this extraordinary experience, expertise, and amazing insights into the topics that we're going to deal with today. So, Rachel, on that note, I will turn it over to you. I think we were going to start with a polling question as well.
We were. Thanks so much, Linda. And the polling question, I'll release that right now, and we'll start with some definitions as well, just to clarify that we're all discussing the same things. Houman, I'll start with you. Linda, in her bio, she mentioned that you've been a law professor for 10 years. You've been teaching in the areas of financial regulation, investment funds, and derivatives, and you also co-founded this startup in legal tech called Clause. So while we're focused on legal tech, there's also so much talk about fintech and regtech. Can you maybe just talk us through, what they are, how they intersect in any way? And do you think there's one that's more likely to be a game changer in their particular industry and future?
Yeah, thanks so much for having me. And I think that's an important question with a general idea being that, software is eating the world, and including in maybe sectors and services that traditionally have not been so enabled or empowered by software. So certainly, I think the one that's been first out of the gate is fintech, not surprisingly, because financial services and finance has historically always been enabled and driven by developments in technology, including decades ago through the application of algorithmic trading patterns to be able to trade stocks and other commodities on exchanges. Over time, that technology has also bled into how companies, especially financial institutions, are complying with a wide variety and increasing variety and demands for regulatory compliance, whether it's capital regulation or different types of risk compliance that's required. So that would be the reg tech part of things. And a perhaps broader category from red tech would be called legal tech, where activities that are traditionally manual and paper-based are becoming increasingly digitized in the legal sector. And as things become digitized, you can perform data analytics and predictive analytics on them, have a much more integrated view of your activities, and make your decision-making data-driven, as well as the holy grail for many of these sectors, legal tech, fintech, and reg tech, is to automate activities, to do things essentially automatically without requiring humans to do anything. Once you can get things set up and processes and workflows and everything else. And so that is, I think, the relationship between those, where reg tech really complements fintech, and legal tech is maybe a broader sector. And with calling these tech, putting it at the end of the word, I think is important too, because it tells us also that there's activity from startups and venture capital, high growth companies are also having an impact. So it's not just incumbents that are developing. Some of them are not still, but it is much of it is being driven, or at least being inspired by what new companies are doing to change the way that existing institutions are practicing.
That's great. Thanks, Humam. And that was sort of in line with the response that we had from the audience on those polling questions about the transactional work and regulatory investigations being the area where legal tech could be most impactful for the future. So thanks for that. And we'll come back to some of those points later on.
Great.
Brilliant. Thanks, Tess. We had a fantastic prep discussion before this edition of the Knowledge Series, and you mentioned that your practice at Morgan Lewis is not a discovery practice, but rather a data practice, and that you're harvesting and leveraging clients' data to enable them to obtain insights on the issues, piece of litigation, or the investigation that they are trying to tackle. Can you elaborate on that for us a little, particularly that description and what you're driving differently with a data practice? And you had some tremendous examples that we spoke about. So if you can share some of those examples, I think that would be terrific. Thank you.
Sure. Well, first, thank you for having me. I'm delighted to be here with you all. As you mentioned, we have evolved as a practice over the course of 2 decades from a practice primarily focused on discovery. When I started in the early 2000s, we were just becoming a digitized business world. And so the proliferation of data created real challenges. And as Humam mentioned, we at first approached electronically stored information in the discovery process very, very much the way we had in a paper-based world. Since that time, the technology has evolved, the quantities of data have continued to climb, and the resources that we can bring to bear to make that process more efficient have really matured the discovery practice. What we have also taken advantage of, though, is the ability to gain greater insights from all of that data, and to enable our clients to make faster, better, more precise business decisions and legal decisions based on what the data is telling us using analytics. We called it predictive coding early on, which was around 2009, 2010, and it continues to evolve. Now we use machine learning and natural language processing as additional tools to harvest information and insight from our data. And so we have expanded our practice significantly since the early 2000s from a discovery, investigation, evidence-based practice to a data practice. We assist clients through the entire life cycle of their information in the area of information governance, data privacy, and we leverage tools now to deliver services to our clients, including automation, and including algorithmic analysis throughout our practice. So one example I think that I've mentioned before is we call them bots, but they're algorithms that we use to analyze data. In the discovery space, we used to throw hordes of lawyers at enormous sums of data to have them review from the first document to the millionth document. Today, we can use algorithms to really get our arms around what the data is saying to us in a much more efficient way. So one of the first algorithms that we developed was focused on the Me Too investigation space. We have a large labor and employment practice, and many of our lawyers in that practice have been assisting clients in workplace harassment and similar claims. And our aim there is to understand the nature of claims and allegations very quickly. And we're able to leverage our algorithm, our Me Too bot, as we call it, to quickly get our arms around the kind of normative community behavior, which we would consider the pattern, and then to identify any anomalies in that normative community behavior that might be indicative of the sorts of claims that you'd expect in a Me Too situation. Algorithms they're not making value judgments, so they're not saying, the data that the algorithm will call attention to as an anomaly is not saying this is bad behavior, it's saying it's different behavior. And so the example I like to use is if the normative community behaviors that we all email with one another 9 to 5, Monday through Friday, talking about accounting and finance, an anomaly might be a text message between two of the participants in that group off hours on a different topic. Maybe perfectly innocuous. And again, the algorithm doesn't value that communication, but it flags it as different, inconsistent with the pattern. And that is fundamentally what our algorithms do. But we can do that much faster, much sooner than we would have if we had 20 lawyers looking at the same set of data. Those 20 lawyers may not be able to make the connections that the data can make. And so it's opened up a world of possibilities for our clients and given us new tools to assist our clients in addressing their business and legal issues.
Mm. And we've heard a lot over time about the loss of jobs for lawyers as a result of technology coming in. From what you've just said, it's really that it's not a value judgment from the bot, but it's rather just providing some data. Would you say that's much more challenging, better work for lawyers? So you're actually providing something a little bit more interesting than old style sifting through a gazillion documents and all of that. So probably opened up, do you think, better, more challenging work and more value work for lawyers, particularly the younger lawyers, lower down who are making their way up to partnership, I guess?
Yeah, I think the nature of the work has definitely evolved. And what I like to say is, rather than the robots replacing all the lawyers, which isn't likely to happen, the work and the nature of the technology enables us to sort out the sorts of work that we're doing. And I predict that lawyers will spend more of their time doing what we all went to law school for, which is legal analysis and argument and research and advice to our clients, where the algorithms and automation will free us from some of the more routine tasks that we probably ought not to have been doing in the first place, but was the habit of practice. And so we'll see a sorting out. Lawyers get to do more of what they trained to do, and the algorithms and technology platforms make the rest of the more administrative aspects of our work focus that have the computers do that instead. So we'll be more efficient. And our work should be more interesting. It's interesting now, but we'll do more of what we like or what we're trained to do.
Mm-hmm. Rachel.
That's great. Thanks, Tess. And I think that's a really interesting use case that you gave with the Me Too movement. And I'd like to come back to the points on predictive coding as well and get Eric and Human's view. But before I do that, question for Eric, and we'll just start a new poll as it relates to litigation funding. Eric, this is obviously your area of expertise, and we've discussed previously that your industry is gathering data from the courts so that you can find a measure of predictability in your outcomes, which then informs your decisions of taking cases. How's that working for you in terms of confidence levels in your cases? And in the current circumstance, does that lead to the potential to more cases being funded, given the greater volumes that are coming to you?
Sure, and thank you guys for organizing and for assembling everyone today. Really grateful to be included. So in answer to your question, Therium, like many in the legal industry, are coping with data overload and the ability to manage that data and to use that data in the most efficient manner to result in more efficiencies and effective use of our limited resources to do what we at Therium do, which is to deploy capital to plaintiff side litigants generally, although we do occasionally fund defense side work, who lack the resources to take otherwise meritorious cases to conclusion. And so that means Therium, we are solicited quite frequently. We are, depending upon market cap of our two largest competitors, anywhere from the largest litigation funder in the world on any particular day to the third largest. And that means we receive solicitations and requests for funding from really all over the world. We have offices in New York, London, Spain, Italy, Germany, Australia. And so that inundation of data requires us to sift through all of the mountains of inquiries to get to those claims that we think are the most meritorious. And so back when I was a baby litigator, similar to what Tess was explaining earlier, we would have mountains of junior lawyers, myself being one of them early in my career, just going through, whether it was discovery related, thousands of emails, manually coding, just putting those into boxes of responsive, not responsive, privilege or otherwise. In large part, that's where Therium is now with respect to the intake of the claims that come our way. They have to be assigned to a human, a lawyer who is able to understand, read, process, and make a value judgment as to whether that particular claim has merit and should otherwise be passed up the queue for further consideration or should be, marked and rejected as not ripe or appropriate for funding. So to complement that, Therium has been making substantial investments in various technological startups, which are taking some of the tools that Tess has described and Hamoon have described in different iterations and applied that to ultimately, which is in some ways the holy grail, I think, at least in the dispute resolution aspect of the application of this technology, which is, well, if most disputes arise from a set of facts which have, by and large, the patterns of which have occurred before, can you plug in the inputs for those particular disputes, the various elements of that particular dispute, and come up with a predictive result? And so that's what Therium in part does. We have an analytic component that we utilize in conjunction with our human review. And that does two things. The first thing is it doesn't replace the human review, but it certainly allows us to get some semblance as to whether the basic broad parameters of which the funding requirements we have internally are being met for purposes of determining whether a particular case warrants further consideration. We found, at least at present, that the technology to accomplish that goal is not quite where we wish it would be. Subtle changes in the data inputs can result in confidence ratios skewing wildly, even if the cases are more or less identical. So we can have two fundamentally linked cases arising from the same transaction or occurrences, and you change simply, one of the most minor inputs, and we'll have a 98% confidence ratio that a case will resolve in, X way, and then you change it and it'll drop to, 30% or 40% or sometimes even lower, which causes us to use that predictive tool at best as a complement to the human element. So unlike Tess, who's able to rely upon so many of the sentiment analyses and related algorithmic searching of the data to come up with anomalies, to come up to a result, at least on the predictive side, Therium is not in a place where we can use that technology to supplant the human element of what we do. Maybe we'll get there. I don't know. But it has led to a more interesting application of the tool or the specific tools that we're talking about, and that is in the marketing and procurement of cases that may warrant the applicability of funding. And what I mean by that is everyone's e-filing on state and federal courts throughout at least the United States. And so that data is publicly available. And so if there's certain kinds of claims with certain damages ratios, with certain jurisdictions that apply, Therium is at least able to capture that data and then proactively solicit the lawyers who might be handling those particular cases to determine whether there is a need for funding as opposed to waiting for those lawyers to proactively scratch their heads and say, hey, wait a minute, maybe we need funding, maybe my client is fee fatigued, maybe there's some type of rationale or reason why litigation funding might be appropriate. And so we're able to capture those particular cases more easily and engage, at least at the outset, with the relevant stakeholders, when in previous iterations and absent the use of that technology, we would not be in a position to do so. So this application and the use of this data is fundamentally impacting all areas and elements of the legal industry writ large, and litigation finance is no exception to that. It's simply a question of the evolution and how that data-driven technology will allow us to evolve, change, and hopefully become better at what we're doing.
And we asked a polling question to the audience on, do you think the current pandemic has resulted in more or fewer cases? And we had 51% of respondents say that they thought COVID would have resulted in more cases for litigation funding. Can you give some comments on that as well? Have you seen an uptick?
We've seen a tremendous uptick, and it makes a lot of sense. If you presume, one, that litigation finance is non-correlated to broader asset classes, meaning people will litigate in good times and bad times, and it sort of doesn't necessarily matter, and that there are certain subject areas that are not just non-correlated, that they're counter-correlated, whether it's insolvency work or certain kinds of breach of contract claims or otherwise, then you would absolutely expect to see an uptick of cases. What makes the current pandemic even more even more robust for purposes of increasing the pipeline of deal flow for litigation funding is that in the stereotypical litigation funding transaction, you have a smaller plaintiff side litigant seeking to procure capital because they cannot afford to prosecute their matter against a larger defendant. Now, that paradigm is actually not accurate to what Therium does as a day-to-day basis. We're funding large corporations, small corporations, and in fact, we have an ebook that's being released today on the application of litigation funding for large corporate plaintiffs or for affirmative claims programs. But the point of that simply is everyone is hurting now. The impact of COVID-19 across more or less every single sector of the economy has resulted in tremendous cash flow constraints for so many different individuals, entities, and corporations throughout a multitude of different circumstances and otherwise. And so that sheer reality of we need to preserve capital, we need to ensure that we can pay our employees, pay our health insurance to make sure that people are protected and safe, to retrofit our offices, to promote home learning or otherwise, at the expense of funneling money to litigation budgets, which may have a 3 to 5 year time horizon. That in and of itself has resulted in a huge amount of increased deal flow and otherwise coming to Therium's way. And from a lot of more otherwise well-heeled clients that would not necessarily have traditionally sought litigation funding in the past. And so that means that Therium is at least as busy as we've ever been since March. I think the analytics on that is our case intake amounts have gone up by as much of a third since March. We're still funding the same percentages. Therium funds around 3 to 5% of the cases that come through the door, and that metric hasn't moved, and in fact, it's probably decreased because just notwithstanding that we're seeing an increased volume of cases, the discipline and rigor which goes into the underwriting still remains the same, and we really are selective in making sure that we're funding those cases that are going to meet our investment metrics, which involve the likelihood of success in the merits, quantum of damages, timing of recovery, and judgment of the lawyers. And so we're seeing an increased number of cases, but that doesn't necessarily mean we're funding an increased number of cases.
Yeah, that makes sense. And I guess litigation funding, by its very nature, is a very much a recession or down-proof, resilient industry. We are going to open it up to some questions that we can all discuss now. But before I hand over to Linda, I'd just like to release another polling question. I promise it's the last one to our audience members. And we'll just be going to a bit further detail about the predictive coding that we've discussed earlier.
Thanks, Rachel. And based upon that polling question, I wanted to, the question to all of the panelists, but starting with you, Herman, I really wanted to tap into whether or not the technology that you're seeing and the uses of it, and what any trends, is it truly a seismic shift? Is it somewhere in between? Is it just another, oh, here we go, here's another wave of different technology, and there'll be the next and the next, but this, at the end of the day, it's a flat line through it. So do you think we're in sustainable transformational territory, or are we going through well, this might work, this mightn't, and we don't know actually what is going to be a success at the end?
Yeah, in my opinion, I do see the change being seismic, but maybe relatively glacial in its pace. I do think over time you continue to see more sophisticated and more accessible application of things like AI or data analytics to all aspects, really, of, let's say, legal practice and adjacent areas. So I do think the way people are thinking about how they go about their day-to-day activities, not to mention their more fundamental activities that are really what goes to the core of being an attorney or exercising judgment will be changing, and will be, as the prior commentators alluded to, really requiring to be informed by some type of data driven analysis or decision making. So I don't think that it's any kind of fad. I do think that it's still taking time. There's so many systems, so many approaches, lack of standardization, lack of education and training. But I definitely think that things are changing. However slow, they are quite fundamental. And again, because the tools are becoming even more sophisticated, and I think importantly, even more accessible and easy to use. So part of it, I think, is you're seeing a lot of platforms talk about no code and making these technologies available to be used and customized and implemented by professionals that are not technically or historically in the technical sector, in the sense of being an IT professional or even knowing how to code at all, including AI. There's lots of AI systems, not to mention application development more generally, that does not require any extensive background by any means in coding or computer science. And so as attorneys, compliance professionals, people on the financial side of financial services, on the business side, they can use apps and they can create apps for their clients internally. I think you're going to see a rapid proliferation of technology of the type we're talking about.
Interesting. And just looking at the results so far, which is probably most results, insofar as that over 2/3 of the responses here think that I think the industry and a lawyer's practice will fundamentally change. So, that is an overwhelming view on that. Can I just ask you how that bears with your teaching with academia at the university and, at Stanford, how that is permeating into the way that you're teaching at the moment?
Yeah, in my teaching at New York Law School and my research at Stanford is really all driven. I mean, certainly the Stanford part, and then increasingly in the classroom on a day-to-day basis is technology. So in the sense that there's still the core of legal education, in other words, the subject matter expertise and the methodology that's required, but as well as how that is being changed and being enabled further by technology. So in the classroom, we will do exercises that require students to maybe learn a new technology or implement it somehow as an exercise, as well as things like hackathons. So earlier this year at New York Law School, we did a hackathon where students created their own software applications in a variety of matters, from matter management to regulatory compliance, and had a competition on the basis of that. Currently at New York Law School, we are learning the Microsoft Power Platform, which is also a low-code or no-code platform for really internal, primarily legal operations development, and developing applications there, for example, to automatically save and scan your email attachments, put them in a folder, and then make a decision based on, let's say, the results of some kind of algorithmic analysis of the contents of that email.
Yeah, interesting. Tess, for you, I just wanted to pick up a question from tremendous expert in this field in Ireland, from Karen Harty, that's come in on a Q&A, which is 12 months ago, no one could have imagined major law firms operating fully remotely. The change has already begun. And has the legal profession in the US been too slow to accept alternative legal service providers? So an interesting question, slightly, segue from what we are, but an interesting question, if you would be able to deal with that.
Sure. So on the question of moving a major law firm to a fully remote operation, it was, at least for our firm, remarkably smooth. We had the fundamental technology and resources in place to open up our pipe and make sure that our systems could function well with the entire law firm being remote. And I understand that that's been largely true of most of what you'd call big law. We've been able to move to fully remote, remain fully remote. If you hear my dogs in the background, I apologize. And that has been, I think, there's been a lot of learning during that process, both for law firm management on the notion of remote work, what work means, retaining your culture and so forth. And I think a lot of those challenges are still to be worked out, because I don't know that we will ever go back to a fully in-office workforce again. And it opens up a lot of interesting questions that we're only really beginning to grapple with. The other question was about competition. And the polling was interesting because it asked about the kind of disruption to the legal industry. If you look at it solely from the legal profession and how it impacts law firms, I think you're missing a lot of what's really going on. I'm not sure that we're going to experience a disruption. I agree with Shuman that there's going to be big change, but it moves at a glacial pace. I think it's going to quicken as a result of a couple of things. I mean, we haven't touched on Rule 5.4, which opens up law firms to, I hate to use the term, but non-lawyer ownership or interests. I think that opens up a lot of possibilities. In my specific practice area, we have had increased competition, both from the big four accounting firms, as well as legal tech startups and a host of other organizations, staffing companies, building technology capabilities, law firms spinning off subsidiaries. So the industry is much more dynamic and evolving at a much faster pace than what the profession has. It's the kind of insulated law firm experience has, I think, reflected so far. I expect that pace to continue. The increased competition, demand from clients to leverage technology better and to harvest, and harness the power of their data is all pushing that forward as well. So I don't know that we're going to see disruption. I do think that COVID, like the financial troubles the U.S. And world experienced in 2009, I think COVID is going to be another instigator of change. Whether it's as a result of the remote workforce, I'm not so sure. It certainly has shown what technology can do, and I think that's good for the profession.
Absolutely. Eric, your view on the difference between seismic shift and just another fad that we're going through. Where do you sit on that spectrum?
I think inevitably the seismic shifts will be arising. It's a combination of seismic shifts yet glacial at the same point. So it's sort of this weird conundrum where the technology is trying to catch up with the data. And so how long it takes for the two to sort of marry to a place of harmony remains to be seen. But to me, what's interesting is not just, some of the points that Tess and Hamoon have raised with respect to how the use of technology impacts, for example, Hamoon with respect to his academic practice, or Tess with respect to, the remote transition of work. Again, it's all facets of the legal industry. So as a litigation funder, I talked a couple moments ago about the non-correlative aspect of the asset class, but that presumes people are litigating. Well, courts have been shut down in many jurisdictions for quite a while now, and how those courts are able to cope with, socially distanced and COVID-friendly work environments remains a challenge. With some courts now, trying to recreate courtrooms with plexiglass in front of each other, and lawyers, marked in a certain place so that the art of advocacy and cross-examination can still continue on an in-person basis. Good luck with that occurring in any real level of efficiency. I think New York City recently just had its first COVID-friendly criminal trial, let alone civil trials beginning in any real earnest. And you multiply that in now towards what we're seeing, at least in a lot of our arbitral cases that we funded, which are now occurring virtually. And a lot of times by, after some initial resistance from the plaintiffs and defendants, because everyone wanted to be in person and be able to test the credibility of the witness by direct cross-examination, over the course of Zoom. And that really is a fundamental sea shift, and the acceptance of lawyers and allowing that to occur is really significant. And it's not just in arbitration, it's in mediation. And inevitably, are courts now going to allow virtual trials to occur? If so, how will that impact not just the day-to-day advocacy issues of how one addresses a jury, but more importantly, how the federal rules of civil procedure, the federal rules of evidence are going to have to be addressed to contemplate people, sitting at home in their room and potentially, reverting to or dealing with evidence that, has to be transmitted virtually or physically before a person. And all of these types of issues, I think, are fundamentally resulting in a sea shift of the application of that technology to the day-to-day normal of what we're dealing with in a pandemic environment. And it's fascinating to watch the evolution occur. By the same token, it's also very challenging in all of the individual areas of the particular industries that are represented on this panel. Where this winds up, I hope it winds up with a vaccine, frankly, and we're not dealing with this, situation because, frankly, people need to remain healthy and safe as a first priority, and we're dealing with it because it results in simple efficiency. Now it's a question of triage and survival, but make no mistake, the use of that technology is impacting every aspect of everything that we do day to day and all elements of the legal industry.
Fascinating.
That kind
Rachel?
that sort of segues quite nicely into another audience question that we have. And I think, Eric, you did partly answer this, but I'll add a piece on the end. Even though law firms, funders, and law schools are implementing technology, what about the courts in the US? They seem to be lagging. But maybe you could give your views on, please all contribute here. Is some of the pushback, is it from a willingness or an ability, or a little bit of both? And if there is a pushback in terms of willingness, where is that mainly being driven from?
So was that for Houman or for myself?
Go ahead.
What's that?
Perhaps we start with you, and then Houman can give his views as well.
Sure. I think it's a combination of both, reticence as well as lack of familiarity, as well as budgetary constraints, as well as, all the other myriad of factors that people are all dealing with. People have operated in a very particular way for generations and generations, and to sort of change that and convert people to a new way of thinking and a new way of, dealing with time-honored traditions is hard. Having said that, the result of the pandemic has caused a new reality to set in and resulted in people having to throw away that old normal and take steps that would otherwise not have been taken. It's accelerating, I think, the use of that technology in ways that wouldn't have been foreseen, whether it was 6 months, 3 months, or however much time this pandemic has been going on. But Houman, I'm curious to get your views.
Yeah, no, I think that's right. Certainly I would look at the court system and governmental institutions as probably not the first movers, just because of tradition, incentives, and budget. But I do think that the parties, like litigants, can and will often be increasingly sophisticated technology-wise, where the litigation may demand it. And just to be clear, I do think already seismic shifts have happened in legal practice, especially when it comes to discovery. Even work that I was doing when I was a young lawyer is not being done in the same way at all. Looking through boxes in a room, even that was starting to go out of phase in the early 2000s. But I suspect that no one's in a room anymore for a litigation of any significant value with 5 of their attorney colleagues looking through boxes at all anymore. It just makes sense, and it doesn't really just do the client's service that way. So that is, I think, a very large shift already, and that's old, quite frankly.
Yeah, it does seem like it's a lot of that grunt work is getting taken out of the sort of the young lawyers' workload, and I guess this also impacts the type of skills required. And Hooman, you touched on this as well earlier, but Tess, I'd be interested to hear your view as well as to, what are the necessary skills for the next generation of lawyers, and are we seeing more, I guess the younger generation is maybe naturally a bit more open and, more effective with technology anyway than the older generation. But in terms of skills required, what are you seeing there? Tess, perhaps we start with you.
Sure, and it's a great question. I had a client give a talk on this very topic within the last year, and she calls the future lawyer the legal athlete, meaning, and I agree with her, that lawyers of the future need to have a much more diverse set of skills. It is not enough to have done well in law school and pass the bar. That's sort of the price of entry. To be successful in the future, lawyers don't have to know how to code, but they certainly need to be well engaged and be able to use technology and understand how technology can impact practice. Another piece that has been talked about very much, though, is the skills of a lawyer in, I call it being a general contractor, because the legal profession has been disaggregated so completely over the last number of years. The lawyer of the future, the legal athlete, needs to be excellent at process and project management and people management to pull all of these disparate resources together to get everyone rowing in the same direction towards the client's aims. And so having the ability to understand and manage a process and a group of people with diverse skill sets, legal design, continuous process improvement, Six Sigma, all of those methodologies will be important. Not one, I'm not favoring one versus the other, but a lawyer will need to have more than just kind of raw legal aptitude, for sure.
Yeah, absolutely. Interdisciplinary practice, I really think, is the future. And the law is at the intersection of so many different things, from compliance to operation to business, to broader strategy, public policy concerns, and ethics, such as Me Too. But I think actually it's a very exciting time to be a lawyer. Despite the economy, despite large student debt, which is a problem that needs to be addressed, legal and law, I think, is very exciting in many ways.
Just to follow up on that, your Rule 5.4 Tess point, I think, is very important and complements what Hooman just said. Just for everyone's edification, Rule 5.4, generally speaking, has barred non-lawyers from taking an ownership interest in law firms or otherwise permitting non-lawyers to really engage in the financial rewards of a particular law firm. In Arizona recently just did away completely with Rule 5.4. So what does that mean for purposes of not just the implications of, technology firms partnering with law firms, but, accounting firms or otherwise? Like, what is the norm of the law firm of the 22nd century, right? Like, what will that evolve? What will that look like? And it probably will look very different from, the law firms that Hooman, myself, and Tess all grew up in. And Arizona serves as a petri dish for that right now, and I think you're going to see a lot of changes following from that.
Yeah, I mean, I've seen at least a couple law firms launching consulting arms, very traditional legal service. And we talk about legal services more than practicing law, and I think there's a reason for that as well.
Completely agree. It's been particularly, I was simply going to add that it's been particularly interesting to watch what's happening in the larger ecosystem, the investments that the large accounting firms have made over the last several years, buying Pangea 3, the large legal process outsourcing organization, the tech plays that they've made, all of that, if you are looking downstream, is by design, and to play in the legal market space in the U.S., where they're now, at least in some jurisdictions, going to be able to launch legal service providers in a much more meaningful way.
And Derek, I was going to ask, there's quite a lot of interest with law firms with litigation funders, correct? Being able to draw on a relationship with a litigation funder for clients. Is there a lot of movement in that, particularly as a result of the current circumstances?
There is. I've been doing this now I'm getting old, longer than I just makes me realize. Separated from government in 2008, I want to say, 2007, I don't even remember it now. It's 2020, so 13, 14 years ago. And when I reverted back into private practice, I started working with litigation funders on just single one-off case investment underwriting analysis. Is this a good investment? Is this a bad investment? Which would result with, me going on to Westlaw, plugging away and doing basic legal research, all the core skill sets that lawyers need to, maintain and have to perform their duties. And then when I joined Therium, who was a client to launch their US operations, so much of our work was still focused on that core one-off single case investment type work. And that evolution has moved forward now, where we're providing much more complicated financial products in the form of portfolio products, lines of credits, financial instruments, or others, not just to law firms, but to corporate entities that, a whole host of different circumstances, whether it is because the law firms are seeking to expand their businesses. Recently, for example, we funded a startup law firm that had a really unique and interesting business model that was very different than your traditional legal, services startup. And we were able to provide their capital, and for that law firm to move forward and execute on their business plan was rewarding. While, in contrast, we're closing on a very substantial transaction for a very, major multinational law firm right now that has a series of COVID-related claims that have arisen directly as a result of the pandemic. And that is combined with the particular clients who are otherwise would have paid, traditional hourly rates and just lack the ability to do that. So Therium will be providing a very substantial 8-figure portfolio for this particular law firm so that they continue to prosecute those matters. All of those types of things are fundamentally causing the nature of the litigation finance market to change as well, in terms of the types and kinds of products we are offering. And I think it's also because litigation finance is becoming a lot more, it's more of a known commodity. I spend so much of my time no longer going through litigation finance 101, which was something that I used to do very early on in my career. And now I'm talking with very sophisticated counterparties that are acknowledging the value of the illiquid assets in the form of one or more litigations. And it's a conversation with respect to how are we structuring cash flows from that to best grow our business and to best cope with difficult times. And I think that's also a fundamental sea shift.
Interesting. Rachel, I think we're on to the final stretch.
We do still have a couple of unanswered audience questions, so I apologize for that, but we only have a few minutes left. So I would just like to ask a closing question to each of you. A nice easy one to close with, because you've answered some hard questions today, but what are you most excited about in your respective areas over the next 3 to 5 years? And we'll go ladies first, so we'll start with you, Tess.
My practice will continue to evolve, but what I'm really excited about across the entire profession is the expansion of the use of these tools and these capabilities beyond litigation and controversy practice, beyond discovery, to the transactional side. We're starting to see that now, but I think we've only just begun to understand what automation, what analytics can do in the practice. I'm also very eager to see the growth of litigation funding. In fact, it probably shouldn't be called litigation funding any longer, because legal funding can help law firms compete in a much broader legal ecosystem now with the Big Four and ALSPs and other startups. So this is a really interesting time, as Houman said, to be a lawyer and to be engaged in the legal profession.
Great, thanks so much, Tess. And Houman, I'll go with you because you're next on my screen.
Yeah, in addition to all the changes in the way legal is being provided and the business of law, one thing I'm very excited about is lawyers taking a lead role and being essentially software developers without requiring to learn how to code or other skills like that, and really being leaders in the innovation economy. As the barriers to technology development are rapidly coming down and evaporating in many ways, using platforms like Bubble or Brighter or the Microsoft Power Platform or Neotologic or any of the other ones that are really made for these types of things. I think that legal will increasingly become more valuable and have a new seat at the table, as it were, and that's exciting to see.
Fabulous, thanks Houman. And Eric, from you, what are you most excited about in the next 3 to 5 years?
So first, what I'm going to say is going to be very counter to what my two colleagues said, because I'm going to rewind back and hope what I'm about to say does not occur in 3 to 5 years. I'm hoping that it occurs, what I'm about to say, much sooner. And that is frankly for us to do the basic things that we otherwise are incapable of doing, which is meeting in person, attending a conference, shaking someone's hand, going out to lunch, sitting across a table from someone and breaking bread. All of the usual things which have just been so disrupted by just the horrific nature of this pandemic. So that, frankly, is what I'm most excited about when that happens. With respect to the legal industry and legal tech, Ethereum has made so many investments in so much of this predictive analytic side of, the AI machine learning tool, and it's just so not where it needs to be. But just given the raw, computational power increases that are occurring, the ability of the technologists with whom we work to better refine and clean and scrub the data, as well as defining the parameters that make these algorithms run, right? There are still human elements towards the creation of these algorithms to refine them and to get them to be better at what they do. So in 5 years from now, am I going to be able to go to a courthouse door with an adversary, go to a little computer terminal and plug in a couple of things and, have someone, spit out a result? No, but I do think that predictive side will be better utilized, not just as a tool for litigation funders, but also for lawyers to better prepare and assist their cases. And I'm curious to see and excited to see how that evolves.
Thanks so much, Eric. And yeah, all three of you have touched on, this fact that algorithms won't be able to, or definitely cannot yet, make value judgments. So there will always be that human side. I'm going to hand over to Dilip and Linda for some closing words. But just from my side, I wanted to thank you all for your time today. It's been a real pleasure getting to know you. And thank you to all the audience questions as well. So Linda and Dilip, I will hand over to you.
Linda, I will defer to you.
No, Dilip, please, you go.
Okay. Well, firstly, let me thank the ADGM Arbitration Center for making this possible this year. They've been a phenomenal collaborator. They have carried us through the pandemic, gave us this platform, gave us this resources to build this community and keep this dialogue going. So Linda, thank you to you and your team. Rachel, thank you so much for all your hard work and for being such a great moderator through all of the events. And to our panelists, Tess, Eric, Houman, it was really a pleasure having you with us. You are now part of the Knowledge Series alumni group. We will be reaching out to you to contribute in other things that we are doing to keep our community going and keep the dialogue going. And to our audience, thank you so much. Thank you for following us around the world. Thank you for your participation. And we look forward to seeing you next month for the London edition. And so watch this space. You'll see some promos coming out. And we look forward to seeing you all again in a few weeks, and stay safe, everybody. Linda?
Thank you. Just to close, thank you, Dilip, and always great to collaborate with Phoenix. It's terrific. But Tess, Human, Eric, thank you very much. I think that was incredibly insightful, and you. It's rare, I think, to get insights of people really at the coalface and doing some really fascinating, interesting things. So thank you so much for sharing that with us and being part of this, particularly on behalf of ADGM. We really appreciate your time and your contribution to this. So we look forward to keeping in touch. And to our audience, we'll see you at the end of October for the London edition before we come home here in Abu Dhabi in December. So please do stay safe. Thank you very much for being a part of this, joining the dialogue, and to our panelists again, thank you very much. And Rachel, finally to you, thank you so much. It's been terrific to co-moderate. So all the best to all. Thank you.
Thank you.
Thank you.